Hello, I'm Laura Richman, counsel in Mayor Brown's capital markets practice, and I'm based in our Chicago office. Today, I'll be discussing how recent bank failures and resulting intervention by governmental authorities, acquisitions, and subsequent developments may affect the SEC disclosure obligations of public companies that trade in the United States. Materiality, of course, plays a key role in determining when disclosures are required, but there's no bright line one-size-fits-all test. But there are questions that you should start considering in the context of disclosures in this area. For example, how have the banking disruptions impacted your capital and financial resources, including liquidity? Have they impacted your ability to access the capital markets? Is the company at material risk of not meeting any covenants in credit or other agreements? Have your customers or suppliers been materially impacted in a way that could affect your company? And those are just a few of the types of questions you should be considering. Whether any of these inquiries will result in disclosures in SEC filings will depend on the particular facts and circumstances of the company. With that framework, let's delve into the disclosure requirements, starting with the various triggers in current reports on Form 8K. For instance, an Item 101 8K would be required if the company enters into a material agreement or if it materially amends a material agreement. And an Item 102 8K would be needed if a material agreement is terminated. So if as a result of the banking disruptions, a material credit agreement is amended or terminated, or if a new material credit agreement is entered, a Form 8K must be filed. And a new or amended credit facility may also require disclosure under Item 2.03 of Form 8K as the creation of a direct financial obligation. An Item 2.04 8K would be required if the current events trigger defaults that increase or accelerate a direct financial obligation, such as a credit agreement. And an Item 2.06 8K would be needed if the situation were to give rise to a material charge for impairment to one or more of the company's assets in accordance with GAAP. So now let's think about risk factors. Companies need to assess whether they need revised or additional risk factors in their annual reports on Form 10K and quarterly reports on Form 10Q to reflect new and evolving risks from either their direct exposure to insolvency, operational or liquidity concerns, or their indirect exposure through their vendors, suppliers, customers, and lenders. Companies should consider whether credit may be more expensive or more difficult to obtain now. And if a company has significant exposure to assets such as U.S. Treasuries or mortgage-backed securities, it should consider disclosing the potential impact of fluctuations in interest rates on their balance sheet. Again, these are just some of the potential points to take into account when considering risk factor disclosure. I know that many companies have recently prepared their annual risk factor disclosures, but remember, if there are material changes since the 10K, new or updated risk factors would be needed in the 10Q. And even if you can point to something in an existing risk factor that may seem relevant to banking disruptions, keep in mind that if a risk was presented in a risk factor only as hypothetical, the risk factor may need to be updated if the company's already experienced the risk. So given the timing of the bank sector disruptions, you may need to consider risk factor disclosure in your next 10Q. it's certainly something to think about. Companies also need to revisit the MD&A to assess whether the bank disruptions have impacted their financial condition, results of operations, or liquidity. Consider whether it's appropriate to discuss bank and liquidity risk as a known trend or uncertainty in the MD&A, giving management's perspective on how this affects the company. Among the many points to think about before preparing your next MD&A is whether the company has new liquidity challenges, and if so, how is management responding to them? Do difficult decisions need to be made, such as prioritizing uses of limited cash? Have the company's stakeholders been affected in a way that impacts the company's business? Are the company's cash, investment, and loan facilities sufficient to continue funding its capital expenditure requirements, its debt service obligations, and its operating expenses in both the near term and the long term? Has the company drawn down on bank facilities because it hasn't been able to access the capital markets or for other reasons? And there's more. In terms of other disclosure areas, a periodic report may need to disclose legal proceedings. For example, if the banking disruptions prevent a company from meeting its debt service obligations or paying its employees or vendors or suppliers or other third parties. If a company has an upcoming report on Form 10-K, or if it's filing a registration statement, it may need to revise its business disclosure to address the evolving situation of banking disruptions and responses. For example, if the disruption has impacted any of the company's business as a result of liquidity problems or otherwise. And don't forget about exhibits that may be needed for a 10-K, 10-Q, or a registration statement. These could be new material contracts or perhaps instruments defining the rights of security holders. Some companies may want to update the cautionary statements they use in their forward-looking safe harbor language to reflect that banking disruptions and associated developments could impact their forward-looking statements. Companies should also discuss with their accountants whether banking disruptions require any disclosures in the notes to the financial statements. Contingency disclosures is an area that should be carefully assessed. And in extreme cases, it might be necessary to consider whether there's any going concern issues. If a company is considering financing alternatives, the company and its advisors should assess whether, in light of the banking disruptions, all of the company's disclosures are current. And they may want to minimize the gap between earnings announcements and the filing of a 10-K or a 10-Q. Companies should also consider whether they need to make any changes to either their disclosure controls and procedures or their internal control over financial reporting to ensure that these remain effective in light of the banking disruptions. Keep in mind that the SEC has commenced enforcement proceedings in connection with what it determines to be failures of disclosures or procedures. Hopefully, this talk has given you a sense of the breadth of disclosure issues that are potentially relevant to the banking environment we find ourselves living in. To learn more, please visit our Free Writings and Perspectives blog. Thank you.